to be rather, we lawyers are responsible for this. Litigants come with lot of hope. There is a lot of injustice, but then there is an administration of justice. This machinery is an administration justice machinery, and there we pray to the High Court that sir, please exercise the power under section 482 of the Code of Criminal Procedure. Now there, this section is one of the most important provisions that helps ensure the golden triangle of the Indian Constitution. Now please never forget that this section 482 and in new criminal procedure, though it is rather termed as 528, please permit me to refer it as 482 because we are more, for last now my 38 years of practice, I am referring to it as 482. So please pardon me that I will refer it to 482. So saving of 482, I may read for you. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. Now, when we look at the new provisions, section 528 of Bnss, verbatim same, there is absolutely no difference. So therefore I say that we will be referring to 482. Now as far as brief, this section 482, the brief history which I can tell you is this, that the Honorable Supreme Court in the year 1960, first time witnessed the circumstances in which the inherent jurisdiction has to be exercised by the High Court, and that is known as the case of R.P. Kapoor versus State of Punjab, that is 1960 Supreme Court. So therefore there the Supreme Court was called upon to decide the High Court's power under section 482, and that time the Supreme Court has ruled that where there was a legal bar against the institution or continuance of the proceedings. So this is number one. Number two, where the allegations in the first information report or complaint did not make out the offence alleged. Now day in and day out, we are attending the courts. Our friends, we all are addressing the division bench, the single judges also. But basically, we all know that these 482 petitions, they are coming before the division bench of this High Court. And there, the first submission of any lawyer who is appearing for the applicant and who wants, or rather who prays that that particular impugned FIR needs to be quashed. So he naturally prayed to the High Court that please exercise your jurisdiction under section 482. No, that cannot be done under article 227. That cannot be done under section 397 of the Code of Procedure. The only provision enabling the High Court is 482. So therefore, it's the most fascinating part according to me. Then the third one was whether either there was no legal evidence adduced in support of the charge or the evidence adduced clearly or manifestly failed to prove the charges. So these are the three things which we are impressing upon the court, telling the court, trying to convince the court that sir, please appreciate from this end. And therefore, we rather call upon the court that sir, you have this jurisdiction of 482. Please exercise this in favor of my client. And then the court examines this. Now what is the purpose of section 482? Let us go to that. According to me, the purpose of section 482, as we read 482 as it is preventing abuse of process and securing the ends of justice. Now this is the main role. 482 is for that purpose only. But what is that? Now in famous case, you might have heard, you might have read, my learned friends must be aware of that. We have a famous case of Madhulimai versus State of Punjab. And that case, it was held that the High Court has the power to intervene and prevent cases or complaints that are filed with mala fide intentions and or with the sole purpose of harassing someone. Further, the High Courts can also ensure that justice is not denied or delayed due to procedural issues. So this is very important. We always tell the High Court that sir, it's a need of the hour. You please exercise these powers. Now why for? Because we get something from Madhulimai's decision. Madhulimai was a famous political activist of that era. You may be knowing that he was a member of parliament also. a very good orator of that time. I had, of course, an occasion in my life that I could hear him live. But Mr. Madhulimai was confronted with a situation where he was required to approach the Honorable Supreme Court. And there this particular case, Madhulimai versus State of Maharashtra, the Supreme Court dealt with this, that you can't harass a person only because, and that too with malafide intentions. Because the malafide intentions, if they are writ large, if you are in a position to convince the court that, sir, my client is at a receiving end, he is being harassed, he is being put to disrepute, and then you can convince the court that, sir, please exercise the power. Number two, you also pray to the court under section 482 that quashing criminal proceedings is protection of innocent persons. Now this quashing of criminal proceeding is also possible under section 482 of the Crpc. It's not possible in any other provision of law. Sometimes we of course get some petitions, many times of course, that the petitions are filed under article 226 or 227 read with section 482. But one of the honorable judges of this court, the most distinguished one of the judges of this court, the retired judge of this court, Justice Sardas, in one of the hearings of the matter, he told all of us that when you are filing a petition, there is no need to add any article, etc. etc. You file a criminal application under section 482. Because 482, it is inherent powers of the High Court. High Court can do and undo anything. So therefore, please don't attach any other thing with that 482. But only thing is that if you pray to the court that 482 you exercise the jurisdiction, you must establish your case. And that is possible only when this quashing of criminal proceedings or protection of innocent persons. See, ultimately when you are appearing for your client, you are trying to make out a case that, sir, my client is the most innocent person. He is being put to receiving it. And he is the victim of some injustice. Now therefore, if you say that, then the High Court can use the inherent powers in this section 482 to quash the criminal proceedings also. And that is not possible anywhere else. Then the third thing is setting aside illegal orders. That is also possible in 482. Many times you know that there are authorities, tribunals, maybe subordinate courts, they are passing on the face of it, we can tell the High Court that, sir, it is an illegal order. It is not sustainable order. And then in that case, if suppose the High Court is convinced that no, such type of order cannot be passed. Now when can we say to that illegal order? When it's without jurisdiction. You don't have that authority to pass an order. If that is convinced, the court is fully convinced, court definitely exercises power under section 482. Then the third thing is, but the power under section 482, but mind it well, that this power which you pray to the High Court, that please exercise, it's a discretion. It's a discretionary power. So you are coming to the court, telling to the court, as I always tell all my colleagues and my students when I teach law also in law college, that see, an accused has a right. A person who is at the receiving end, if suppose he is victim of the system, and there is a great injustice to him, and then he is going to the courts of law, then to approach the court of law to seek a particular remedy, maybe he is right. His right is there. We are in a democracy. We know what is happening around our country. But fortunately, we have developed. That's why we have been called as the largest democracy. But then believe me, that when you approach to the court, that is a right given to you. But as a matter of right, you cannot tell the court that, sir, please exercise the power. No, it's not possible. You can only tell the court that, sir, please exercise, means then it comes to the discretionary power. Now, discretion is always such that it is to be exercised by the court when court deems it fit and proper. So therefore, this is discretionary. The High Court may in some cases refuse to exercise these powers. Why this is being done? Because High Court is not convinced. High Court do not want to exercise its discretionary powers, and therefore it is being done. So therefore, this thing as such, The section 482 has been developed gradually through various judicial pronouncements. And that is what we get. Fortunately for us, the most